Welcome to Class 6. So far we've learned about the oil and gas industry, projects, stakeholders, and contract vocabulary. Today, we're going to look at contractual risk and why it matters so much in oil and gas projects. Risk is the possibility that something may happen and create a negative consequence. In an oil and gas project, risks can affect safety, costs, schedules, performance, and even the entire project. Contractual risk is risk connected to the rights and obligations created by a contract. The contract should make clear who is responsible when something goes wrong. Oil and gas projects can be particularly risky. They are complex, expensive, and often take years to complete. They may also involve difficult environments, specialized equipment, and many different companies. Some common risks are technical, financial, operational, and legal. A technical problem may affect performance. A financial problem may increase costs. An operational problem may cause delays. Schedule risk is the possibility that a project will take longer than planned. Delays can increase costs and may also create contractual claims or penalties. Cost risk occurs when the actual cost of a project becomes higher than expected. This can happen because of delays, changes in prices, additional work, or unexpected problems. Performance risk concerns whether a company can meet the required standards. For example, equipment may fail to perform according to the technical specifications in the contract. When something goes wrong, an important question is, who is liable? Liability determines who may be legally responsible for a loss, damage, or other consequence. Risk allocation means deciding which party will be responsible for a particular risk. In negotiations, the operator and contractor may have very different views about who should take that risk. One important contractual concept is force majeure. It generally refers to exceptional events outside a party's reasonable control, such as certain natural disasters. Projects don't always go according to the original plan. A change order is a formal way of changing requirements. When a risk creates additional costs or delays, a contractor may submit a claim. The parties then need to determine whether the claim is justified under the contract. Companies don't simply accept risks. They try to manage them. Risk mitigation means taking action to reduce impact. Imagine that severe weather stops offshore operations for several weeks. The project is delayed and costs increase. Who is responsible? Does the contract provide protection for this situation? These are contractual risk questions. This is why precise contract language is so important. If responsibilities are clearly defined, parties understand what should happen. Let's review today's vocabulary. Risk, liability, risk allocation, force majeure, change order, claim, mitigation. Now check your understanding. What is contractual risk? What does liability mean? What is force majeure? Excellent. You now have the basic language. Next class, we'll look at claims, disputes, and the language of disagreement.